A Guide for Immigrants Accused of Crimes in Florida. Written by Joseph Mitkevichus. The Florida Criminal Court Process, Step by Step. The criminal process can be confusing, especially if it's your first time in trouble. Florida's criminal procedure has several steps. Here is a simplified roadmap of what typically happens when you're accused of a crime in Florida, along with what you should do at each stage. Step 1. Arrest and booking. The police arrest you if they believe you committed a crime. They take you to jail and book you, take your fingerprints, photograph, and personal information. They may also list the charges they think you should face. Invoke your right to remain silent and ask for a lawyer, as discussed above. Try to contact family. At the jail, you'll be held until you see a judge or until you post bail, if allowed. Step 2. First appearance, bond hearing. Florida law requires that you see a judge within 24 hours of arrest, often via video from the jail. This is called first appearance. The judge will inform you of the charges, ensure you have a lawyer, assign a public defender if you don't have one, and consider bond, bail. Bond is money or conditions to ensure you return to court. The judge might set a monetary bail amount or release you on conditions, or in serious cases, deny bond, meaning you stay in jail. This hearing is usually quick. Make sure the judge and your lawyer know if you are not a U.S. citizen. This can be as simple as your attorney stating it. Why? Because if there is an ICE detainer on you, or a risk of one, it could affect bond. Sometimes prosecutors argue a defendant is a flight risk if they're undocumented. Also, if ICE has put a hold, even if you post bail, you might not be freed. See the next section on ICE holds. At this hearing, through your lawyer, you can argue for a reasonable bond. Having family present in the courtroom or video can help show community ties. If you have a job, property, or family here, those are points to mention to argue you won't flee. Step 3. Charging by the state. After your arrest, the state attorney's office, the prosecutor, will formally file charges in Florida. For felonies, they file a document called an information or seek an indictment for very serious charges. For misdemeanors, they also file charges similarly. This usually happens within a few weeks. Sometimes charges get changed or even dropped at this stage if evidence is weak, but do not count on that. Stay in touch with your lawyer. They might discuss with the prosecutor early on to see if the charges can be reduced or dismissed. Provide your lawyer any information that could help, for example, proof that you have no criminal record, or evidence that contradicts the accusations. Step 4. Arraignment. This is a court hearing where you enter a plea, typically not guilty at first. In many cases, your lawyer can file a written plea of not guilty, and you might not have to attend this hearing. Ask your lawyer. Pleading not guilty doesn't mean you will definitely go to trial. It just preserves your rights while the case is pending. Almost always, it's wise to plead not guilty at arraignment to give time to review evidence and negotiate. Do not plead guilty or no contest at arraignment just to get it over with. Doing so could instantly harm your immigration status. There is usually no advantage for immigrants to plead guilty at the first hearing. You gain time by waiting and formulating a plan. Step 5. Discovery and pretrial period. After arraignment, there's a period where the defense and prosecution exchange evidence called discovery. Your lawyer will get police reports, witness statements, etc. There may be pretrial hearings or conferences to update the judge on the status, file motions, requests to the court, like to suppress evidence if rights were violated, and discuss possible resolutions. This phase can take a few months or sometimes many months. Work with your lawyer during this time. Help them gather evidence in your favor. For example, if you have alibi witnesses or text messages that prove something or surveillance video, tell your lawyer. Also, use this time to consider the immigration implications. This is when your lawyer should be researching what will happen if you plead to X versus Y charge. If needed, this is when you involve an immigration attorney or expert. Do not let the case rush to a plea without fully understanding the outcome. Sometimes prosecutors will offer a plea deal early to dispose of the case, but quick deals can be dangerous for immigrants. The system often wants efficiency, but efficiency can lead to non-citizens getting railroaded into bad pleas. Take the time you need, within reason, to have your lawyer seek a safe outcome. In this phase, if you are out on bond, stay out of trouble and go to all your court dates. If you are in jail, be patient and focus on your case. Step 6. Plea bargain or trial. Most cases end in a plea bargain. You agree to plead guilty or no contest to one or more charges in exchange for something, like lesser charges or a lighter sentence. You also have the right to a trial where the prosecutor must prove the charges beyond a reasonable doubt. Going to trial can be risky because if you lose, the outcome might be harsher than a plea deal. However, for immigrants, sometimes taking a deal is far riskier for immigration, whereas fighting might be the only chance to avoid deportation. This is a crucial decision point. We will have a whole section on plea versus trial considerations for immigrants below. In short, do not take a plea just because it seems easier or because you want to go home quickly unless and until you are sure of the immigration consequences. Sometimes one charge in a plea can make you deportable, while another slightly different charge might not. It could be worth fighting or negotiating for that safer charge. If you decide to go to trial, make sure you understand the possible maximum sentence and weigh it against the immigration outcome. In some cases, even if you lose at trial, if the conviction is on a charge that doesn't destroy your immigration status, that could be better in the long run than a plea to a deportable offense. These are complex judgments. Get advice from your lawyer and possibly an immigration lawyer. Do not be pressured by statements like, "Everyone takes a plea," or "You'll get more time if you fight." Many immigrants have avoided deportation by choosing to fight or wait for a better offer. We will delve more into this in the next section. Step 7. Sentencing. If you plead guilty or are found guilty at trial, the next step is sentencing. The judge will impose a penalty. It could be probation, jail, prison time, fines, community service, etc., depending on the offense severity and any plea agreement. In Florida, for many charges, there are sentencing guidelines or minimums, but also room for judge's discretion. Before sentencing, you can present mitigating factors, reasons for leniency. This might include your history, contributions, family situation, etc. Important for immigrants. Sometimes the length of sentence imposed can affect immigration. For example, certain offenses are an aggravated felony in immigration law only if the sentence is 1 year or more. If your lawyer can negotiate a sentence of 364 days instead of 365, that might save you from the aggravated felony category. This is a detail to remember. Another example, a withhold of adjudication, not formally convicting you under state law, might still count as a conviction federally, but the sentence length matters. Work with your lawyer to see if avoiding jail or keeping the sentence under a certain threshold could help your immigration situation. If you are not detained by ICE at this point, make sure you follow all sentencing requirements. probation rules, paying fines, etc., because violations can cause rearrest. Step 8. After the case, what next? If you were not taken into ICE custody during the case, you might finish your sentence or probation and then carry on. But depending on the conviction, ICE might still try to detain you after or put you in removal proceedings. If you were on a visa or other status, a conviction might cause that status to be revoked or hard to renew. We will cover the specifics in the section After the Criminal Case, dealing with immigration, ICE, later. Essentially, after your criminal case, you should consult an immigration attorney to see if you are at risk and what your options are. If your case was dismissed or you were acquitted, found not guilty, congratulations. That's the best outcome for immigration. You won't have a conviction. However, if you are undocumented, ICE could still try to deport you for being here unlawfully. The criminal case outcome doesn't give you status. If you have legal status, green card, etc., and charges were dropped, you're generally in a better position. Just be careful in the future. If you were convicted of something, you need to know if that conviction makes you deportable or inadmissible. This might involve legal analysis. Again, talk to an immigration lawyer. In some cases, if your defense lawyer failed to advise you and you pled to something that ruins your status, there may be a possibility to legally challenge that plea later. A motion to withdraw a plea due to ineffective assistance, referencing Padilla. These are hard to win, so it's best to avoid the problem by handling the case right the first time. This overview is a lot to take in, but the key message is, do not rush. The justice system in Florida can move quickly, often pushing quick plea agreements. But as an immigrant, you need to use the time available to seek a safe outcome.